Good evening, this is Rahul Reddy. We are live here every Tuesday at 5 p.m. Central Time. REDDY NEUMANN PC brings in immigration news every Tuesday at 5 p.m. Central Time. For those people who have any questions, please, you can post those questions on YouTube or Facebook. We will try to answer as much as possible. Today, I have my business partner, Chen, with me. Rebecca, what do you have today to discuss?
Hi, thanks for joining us, everyone. So today, we will get to your questions, but first we're going to get some updates on the Fairness for High-Skilled Immigrants Act, which is making its way through the Senate currently. The H-4 EAD updates. So if you've been viewing our videos, you know that we've been filing federal litigation in order to adjudicate those H-4 EADs that have been pending. So we're going to get updates on where those lawsuits are. Also some updates on FDNS Site Visits, especially for H-1B employers. Notices of intent to revoke and the effect that they have on an application or subsequent applications, and also an update on where we are in the lottery process from the H-1Bs filed in April. So first of all, the Fairness for High-Skilled Immigrants Act. This was a Senate bill introduced in February by Senators Mike Lee and Kamala Harris. Where are we on that bill right now?
Well, this was the reflection of the bill, what was there in the House, which was being passed, that has removed the per country quota limit. Mm-hmm. And the Senate, when it was passed in the House, we didn't give it as a good chance. However, when Senator Grassley's amendments, which he proposed for the same version of the bill, were being accepted by Senator Harris, that has some restrictions on the H-1B, but removing the per country quota limit, we expected it to pass through the Senate. However, it seems that Senator Rand Paul put a hold on this bill because he wants to introduce some poison pills into it, which Senator Lee doesn't think that if those things are being included in it, the House is going to pass the same version of it. So it's most probably is going to become dead. So at this point of time, Senator Rand Paul put a hold on it. To take the hold of it, it requires 60 senators to pass that, and that's the filibuster rule, what we call. This is the things that have been adopted as internal rules by the Senate, that if we have to get the hold taken off, we need 60 senator support, which is a workable deal. Most of the senators are supporting it, but we have to see if the 60 senators will come up to make sure that this hold is taken off. And if that hold is taken off, then we can expect things to go through smoothly in the Senate. And of course, we're expecting the same amendments that have been introduced by Senator Grassley be adopted in the House version so that things can go through smoothly. At this point of time, I would request all the audiences who are interested in taking the per country limit off to contact your senators and your congressmen. Mostly this is in the Senate right now. So contact your senators and request them to take the hold off on this one. Just to recap that if the per country quota limit has been taken off, the priority dates for Indians are expected to move, Indians and Chinese are expected to move to 2016. And there will be equality between all the nations if the per country quota limit is going to be taken off. Especially the most countries that will be beneficial will be Indian nationals and Chinese nationals who have been discriminated just because they've been born in those particular countries. So let's see what goes on, but I would request all the audiences to contact the senators to take this hold off and pass this Fairness Act, taking off the per country quota limit.
Yeah.
Now, on the H-4 EADs, Rebecca, can you update anything what's going on the litigation part of it? I know that we are the only law firm that went and sued the immigration. Why did we do it?
Yeah, so if you've been viewing our videos, you know that we filed one lawsuit. We're getting ready to file another one shortly. That requests or demands that USCIS adjudicate the H-4 and EAD applications that have been filed concurrently with an H-1B extension application. And the reason that we've filed these last month and this month is that due to the new biometrics requirement for I-539 applications, which was introduced in March of this year, H-4 applications and concurrently filed EAD applications are no longer premium processed along with the H-1B application, even if they're filed concurrently. And our office has tried every method possible short of litigation, and now we've moved to the litigation step. But we found that this was necessary because no other methods were working. So we have tried every other method available, including the expedite requests that USCIS has a process for online.
Congressional inquiries will be tried.
It used to be that you could contact your congressperson, and congressmen's offices have liaisons with federal agencies like USCIS, so they are meant to help their constituents move through blockages like this one with USCIS, and those have in the past been pretty effective. If your congressman did get involved, it usually was pretty effective, but even that has not been working for the H-4 EAD backlog. And so everything else that we've tried, upgrading to premium after the biometrics has already been done, also has not been effective. And so that's why we felt we needed to file a lawsuit in federal court. And so far, it's still early stages. We will keep updating the audience as we get more results, but we already have some successful results.
We already got the approvals for the cases that were being filed after March 11th, 2019, where the biometrics were being done. These are the only cases that we know of that were being approved are the cases that went through the litigation process. So that is bringing us to go to the next level to file more litigation on this. Hopefully so after we file many, many litigations, the USCIS might just approve in the 30 days time that was been given to them, so that, you know, in future when people are filing the H-4 EADs and H-4s, it might be adjudicated without going to the litigation. But at this point of time, litigation seems to be the only way for these approvals. So we have good results. We're expecting good results in the next set of litigation also. Hopefully the immigration will correct itself and then will approve it. But for now, for those people who are going to lose their jobs without EAD, or who's going to have a negative effect if they're going to lose their jobs, if the EAD is not approved in the proper timing, I mean, you don't have any other way other than going litigation, because they're going to take a long time to adjudicate the H-4 EAD. Now, Rebecca, the FDNS visits have been significantly increased for the H-1B applicant and also other applicants. Can you educate what FDNS visit is and any updates on the FDNS visits?
Sure. So FDNS is the Fraud Detection and National Security Unit of USCIS. It's not a new unit. It's been a part of USCIS for many years. But definitely in the last 2 years or so, the rate of FDNS site visits has increased significantly. And this afternoon there was a teleconference by the USCIS Ombudsman's Office, including an update from a representative from the FDNS unit. So they did give some numbers. So they did point out that there are actually 2 site visit programs that FDNS conducts. One is the site visit program that is for basic compliance. It's somewhat random. Just a certain percentage of approved H-1B applications receive a site visit to check if the conditions of the H-1B employment are still according to what was listed in the petition. That program has been in place for many years. That's not anything new. What has been relatively new is a more targeted site visit program, and it's probably this targeted site visit program that is the result of the increase in perceived site visits in the past 2 years. So the representative on the teleconference this afternoon did point out that there are 3 specific criteria for H-1B employers in particular that leads them to be targeted. One is if the petitioner's information cannot be validated through publicly available means such as Dun & Bradstreet. USCIS does use Dun & Bradstreet quite a bit to validate whether a petitioner is a legitimate business. The second criteria is if the petitioner has a high ratio of H-1B workers, so H-1B dependent companies especially. And the third criteria is if the petitioner files for a lot of beneficiaries that are placed at off-site end client locations. So site visits that are occurring now, sometimes they are the more random kind just for compliance purposes. But if an H-1B employer feels like they are receiving a high rate of site visits within a pretty short period of time, that is probably an indication that they are part of this more targeted site visit program. So in the event of a site visit, what should you do, Rahul? What should employers do?
Employees and employees run away. No,
Yeah.
that's not the case. I'm just kidding. We have seen some of the employers and employees actually doing that, and that surprises us.
Yeah, don't do that.
Don't do
please.
that. When the site visit officer comes into it, we would always want you to make sure that you have read the petition that has been filed with the USCIS and be aware of what has been written in the petition. And if there is any disagreements that you may have in the petition, you should discuss with your employer or your employer's lawyer to sort the things out. The number one thing that we feel the people have lacking is that they don't read the H-1B application. That's the number one lacking thing that we see. The second thing is that the site visit could happen at your end client. Be prepared for it. Don't get shocked. I would want you guys to make some of your colleagues aware, at least your client manager be aware that there is a chance that the government officer might come and ask whether or not you have been employed under a certain profession or not, so that it makes it easier when the officer calls or sends an email for your manager to respond to the query. These are the two simple things that you can do to make yourself aware of it, to make yourself face the FDNS official. They may ask you about your employment history, they may ask you about your job duties, they may ask you about your salary, your W-2 form, whether or not you have paid any money to your employer to do the H-1B. These are the typical things that they may ask. Now, if you are prepared with the H-1B application, you read those things, and if there is any disagreements you have, you should discuss with your employer and your lawyer to make sure that things are in the proper line. And if you don't have any disagreement, you should be aware of what is written in there, and then it will become easier for you to respond when the site visit officer comes in. The other simple steps that we notice is that right now social media has been accessed. Mm-hmm. Today I had a discussion with FDNS official and they spoke and they told us that they have much more information about the employers and employees than what we think. It was out of the discussion. I won't name the officer, but what they said is that they have much more information about the employer and employee than what we think that they know about. We want you guys to be very careful about it. If your social media is reflecting different than that of your H-1B, we may want you to look into it if that's accurate information that you're listing it on the Facebook. If you're employed with, let's say, ABC Consulting company, and you are employed at an end client, let's say, for example, the end client is Orange Inc. So if the end client is Orange Inc., your employer should not be Orange Inc., it should be ABC Consulting Inc. If you're just putting that your end client as an employer, that may be very misleading, and that is being studied by these people for sure. And now it has become an absolute necessary when you go to visa stamping. Mm-hmm. What are the other experience that you have in the FDNS visits, Rebecca?
Yeah, so especially with the increase in the rate of site visits, we have heard reports that if you try to engage the officer who is conducting the site visit and ask them details about your petition, don't be surprised if they don't have very many details or don't seem that familiar with your petition. It appears that the FDNS officers that are sent to the actual work sites to verify the information are really just there to collect data. They're given a list of questions and a list of documents and information that they've been instructed to collect. In a lot of situations, they are contractors. They're not direct employees of DHS. So they probably will not have that much information for you about what's going to happen to all this information that they're collecting. So that was also something that came to light during the teleconference this afternoon. The FDNS officers conducting the site visits gather this information, they take it to the adjudicators who are employees of USCIS, and then the adjudicators make a decision on what to do about the application, if there's any adverse action that needs to be taken. And so don't be surprised if it's after the site visit, if it's several months before you hear anything, because that's just the amount of time it takes for this process, apparently, for the officers to collect the information, turn it over to the adjudicators, and then the adjudicators review it and decide what to do. So leading into that, one possible result of an FDNS site visit, one possible adverse action is a notice of intent to revoke. So if the adjudicating officer reviews the information collected during the site visit, compares it to the petition, and decides that something is inconsistent, a very common course of action they take at that point is to send an NOIR, a notice of intent to revoke. So Rahul, what is the impact of an NOIR, for example, on an H-1B?
Rebecca, most of the notice of intent to revoke, why they are occurring is that we are noticing that some of the companies are filing a H-1B with an in-house project, and this in-house project is what is causing problems.
Yeah.
When the FDNS does visit the employees, they ask a simple question: how many other employees are working at that location? And they will find out how many people are working, because we have noticed that some of the companies have filed a lot of petitions on the in-house project, the so-called in-house projects, which we doubt if there is any in-house project at all. And these employees are not working at that location. Rebecca, even if they file the H-1B right now, I've noticed cases that the H-1Bs were being filed in 2016 with the in-house.
Yeah.
The H-1B is approved, and they have moved to company B and sometimes even company C. They're working with company C. Now they got an intent to revoke for company A. As you pointed out, sometimes it's based off the FDNS and other information that they have. It takes months and sometimes even years to get back to those things, and they're issuing an intent to revoke. Now, if the 2016 H-1B is revoked, even if you're working with company C, you're not safe. The reason why you're not safe is that what the USCIS will tell is that the first application was being filed wrongly, you've been counted wrongly towards H-1B number. Since you have been counted wrongly towards H-1B number, all subsequent H-1Bs are relying on this H-1B count, so they're going to revoke all the other H-1Bs. So please be careful. If you have any intention of filing with the so-called in-house projects that are dubious, don't do that. It's a temporary relief, you may get it, but you will be harmed for sure in the long run. If you have already been filed with the H-1B, with the in-house project, you never work with that company, I would recommend that you contact a lawyer immediately. Not the same lawyer that filed the H-1B application with the in-house, but an independent lawyer to evaluate what is the best steps that are available for you if you have ever filed an intent to, if you have ever filed a H-1B with an in-house project which never existed.
Right, so the most dangerous impact of that is possibly years later, 3, 5, 7 years later, you could be considered to have never been counted in the H-1B lottery. So having to go through the lottery again would be the main consequence of that, which is yeah, extremely difficult. Speaking of the lottery
system,
yeah.
have you on the 2019 April applications for the fiscal year of 2020, have you received any rejection notices of the lottery yet?
So we just started receiving the petitions that were not selected in the lottery this week.
How much percentage of the rejections that you got it right now?
Very few. I don't know the exact percentage, but it's something like
1 to 2%?
1 to 2%. It's they're being very slow this year. I think it's even later this year. I think last year we started receiving the unselected applications in June, and we received our first ones yesterday, July 1st. And part of that, as we've discussed before, is that DHS is definitely doing more data collection even on applications that are not considered officially filed because they weren't selected in the lottery. Nevertheless, they're keeping these applications at the service centers in order to collect a lot of data on them to see who's filing, how many applications total a company is filing, how many applications beneficiaries are having filed on their behalf. So that seems to be why it's taking longer for these petitions to be returned, but we started receiving the first ones yesterday, and based on previous years, it usually takes a few weeks at least for this process to be completed, so it'll probably be a slow trickle through the next 3 weeks or so of receiving the applications back with the filing fee checks.
I have this question from Banerjee with regards to Can an approved I-140 will have any impact on H-4 visa interview? No, zip, zero, nil, nothing at all. H-4 visa can have a dual intent to either settle in United States or not settle in United States. So if you have an I-140 file for either for you or your spouse, will not have any negative impact whatsoever at all for your H-4 interview. It may have on F-1 but not on H-4. Gurnath has this question on the YouTube. Any update on the second set of litigation that you intend to file on the H-4 EAD? We have been getting contacted by a number of people for the second set of litigation. That's filled out because people think so that we expect it to file on July 5th and it's already filled out. It's not like you can just pass the information, we just put in your name and file an application. We need to know a lot of details, the story about you, what is impacting, and we need to present a good case in front of the federal judge who is appointed by the President of the United States. So it's not like we can just file the application. This second set, we are expecting it to file on July 5th, which is this Friday, but our office is already filled up with the applications. The next set, which we're expecting to file in the July 16th to 19th, somewhere around that area. If you are interested in retaining our services, that would be ideal for you if you have not already given your case to us on the H-4 EAD. As Rebecca has pointed out, we have tried to do everything. Litigation seems to be the only way that is working for our clients and the only way that the immigration seems to be listening to. Not the Congress people, not the expedited. There are very sad stories. Doctors working, researchers working, losing their jobs because of that. So litigation is the only way. What basis are we going to the litigation is very important, because in the legislature, that means in the Congress, when they pass the laws, they expected the immigration to adjudicate the non-immigration applications in 30 days. So when we file a H-4 application, if they don't adjudicate the 30 days, that is giving raise for us, that is giving a legal cause of action for us to go to the court and tell the court, look, the Congress said they're supposed to adjudicate in 30 days, they're not adjudicating 30 days. Unfortunately, can we expect a result as soon as we file the litigation? Yes, we did get some results after filing within 1 week or 10 days. We did get some results on that. But typically we do expect anywhere between 30 days to 60 days. That's when we get the result. So what the USCIS most probably will do with these litigation is that instead of going to the judge and explaining them why is it taking more than 30 days when they are charging so much money to adjudicate the application, they will just adjudicate this application, they approve those applications, and then we don't have any reason to continue with the complaint because our case is already approved. We don't have any face to go in front of the judge. We will end up withdrawing the complaint that we made. That is the most probable result that might happen. So that's the reason why we are litigating. That's a probable result of what happened. Now, of course, previous results are not a guarantee that the next litigation will go through the same thing. We have to give this one to you that it's not guaranteed, but we're expecting good results coming from the litigation. Anything from Facebook?
Yeah, so Vignesh from Facebook asks, if an H-1B transfer is denied in premium processing, can it then be appealed by satisfying the reason for the denial? So any H-1B denial can always be appealed. There's always that option. However, it sounds like Vignesh is asking, for example, if the H-1B was denied for lack of an end client letter, which is a very common reason for denial these days, especially if it's at a third-party client site, can you submit the client letter in the I-290B appeal or the motion to reopen and get the H-1B approved that way? Unfortunately not, or at least the chances of success on appeal are not very good. In general, the chances of success on appeal are not very good, even if the denial was issued incorrectly or in error. It's very difficult to get USCIS and the AAO to reverse a denial decision.
I have this question, Rebecca. Mm-hmm. Is the appeal the only option available, or are there any other better options for the people rather than appeal? Can they refile the H-1B
Yeah.
application?
Yeah, definitely in this situation, especially since we have premium processing back this year, we would normally recommend refiling the application in premium processing. Depending on the status of the I-94, of course, we would warn that there's a possibility that the I-94 may not be issued with the refiled transfer application, in which case you would need to depart the U.S., apply for the visa stamp, and return in order to get back into H-1B status. But because there's premium processing, that is going to be a much faster option than appealing, especially if you have the missing piece from the previous application that resulted in the denial. If you have the end client now, for example, it's going to be a much better option to just refile in premium processing.
Ashok has this question: are you part of the IT serve? Did the IT serve play any role in blocking the Senator 386? No, IT serve never blocked anything 386. It's some cut and paste of some video thing that has been presented by some people who don't even name who are there. They just cut and pasted all different parts of it. IT-Serv never did it. It's just a miscommunication. I don't want to keep on going on the same cut and paste of the video. Please, come on, be educated and move on to that thing. IT-Serv has done very many efforts in taking the per country quota limit off. In fact, IT-Serv is the only litigant that has changed the stem extension part of it. It is the only litigant that has gone to the stem extension and removed the third part that the persons can work at third party site and the stem extension. It is only IT-Serv that did it. Of course, we did help them out in the litigation process of that. Our colleague, Jonathan Wasden, who is the lawyer, is the one who litigated the matter for the IT-Serv in taking those things. Not only that, IT-Serv was also litigated on the issue of the taking the denials of the H-1B based on the February 22nd memo of 2018. It has been an instrumental part of it. Please don't believe in those rumors that have been. We know who is doing it, but they don't even name their name on that on the videos that have cut and paste on those things.
Avinash from Facebook asks, he's changed from company A to company B and his previous employer revoked the petition. Is that an issue? So if it was company A that withdrew the petition themselves because you left their employment, that is not an issue. If you've already switched over to company B, that's not a problem. The revocation issue that we were mentioning before is when USCIS revokes the application rather than a voluntary withdrawal by the petitioner. So there's more of a problem if it's USCIS revoking its approval of the application because they believe it was incorrectly approved and shouldn't have been approved in the first place. That is much more dangerous, especially if it was a capped subject application. But in Avinash's situation, that should be fine as long as you've moved over to company B before the withdrawal occurred.
Rakesh has this question. His wife is an H-4 EAD based on his I-140 approval with company A. Now he moved to company B. Can his wife continue working on the H-4 EAD that is still valid, though he's not working with a company that has the I-140 approval? Rakesh from YouTube, yes, she can continue working on the EAD. Absolutely no problem, as long as the validity of the H-4 EAD is there. Even though you're not working for the company for the which you got I-140, your wife can continue working.
Shosh asks, what are the options apart from FOIA to get the approved I-140 approval notice? Unfortunately, I don't think we know of any other options besides the petitioner providing it to you. So far, the FOIA request has been the only way to get evidence for the beneficiary to get evidence that he or she has an I-140 approved. There is a new FOIA system that is online. It used to be an actual paper form that you sent through the mail, and USCIS recently rolled out an online FOIA system. So that may help it be a little bit more easy to file. Hopefully it would speed it up a bit because right now It takes, I would say, 3 to 4 months at least to get the results of a FOIA request. So we'll see if the online system speeds it up a bit.
Suresh has this question. His H-1B approval got with a predated April 30th as approval. What are the options? Should he leave the country? We have litigated this case. Jonathan Boston has argued in behalf of us in the federal court. We were able to get that one reversed in the federal court. In fact, after we filed the case, within 1 day, they approved the H-1B with 2 years and 9 months. I don't know why they didn't give us 3 years, but 2 years and 9 months. That's one way of it. It's a costly way of doing it. The second way, there's an also option called non-protunct argument, that you fell out of status not because of your mistake, but because of extraordinary circumstances, because that are beyond your control, and you can file a H-1B application extending the H-1B. That is an option. However, I would want you to discuss with your lawyer if they want to use that option. It's called non-protunct. That means, please excuse me for the extraordinary circumstances that I have gone through, and give me the extension even though my status is not legal right now. That's called non-protunct. You can try that option too. Question Prabhakaran has been doing on the YouTube more is, what kind of non-immigrant visas available for startups? Well, it's a very broad question. There is A, B, C, D. I mean, not A visa, but there are many different options depending on the circumstances, what you're eligible. Are you eligible for E visa? Are you eligible for O visa, P visa, Q visa? There are many visas. We can't just tell visas that H visas, L visas, most of them might be eligible for. You have to go to the specific question what you exactly want. You may want to consult with a lawyer with regards to this, what are the options available.
Shosh asks, is day trading, buying and selling stocks, acceptable on an H-1B? So we have discussed this a bit before in the videos, like what level of investing or trading is acceptable for someone on an H-1B visa. And in general, day trading, we've said if it's only buying and selling stocks without active involvement in the operation of the company, should be fine on H-1B. That's considered just investment in stocks.
I have the follow-up question on that, Rebecca. Is Uber and Lyft on H-1B, is that allowed? Working for Uber and Lyft?
No.
Okay.
That would be considered employment, working for wages, basically. So for H-1B visa holders, you're only authorized to work for the company that sponsored your H-1B visa, or companies if you have concurrent H-1B approvals. But you're only authorized, it's very limited, you're only authorized to work for the H-1B petitioner according to the exact terms listed in the H-1B petition. If there are even any significant changes to the terms of employment, an amendment needs to be filed in order for you to continue being authorized. So any other involvement, active involvement in running a company, operating a company that you own, would probably be considered unauthorized employment in that situation. Day trading is fine.
Day trading is fine. Uber and Lyft is not fine.
No.
Ramtik from YouTube has this question. He submitted the expired I-94. By mistake, he actually had an updated I-94. He did not submit it, and his H-1B got selected in the lottery. Will he get a rejection of the H-1B because he submitted the expired I-94, though he has a valid I-94? I don't think so it will be rejected. The USCIS will go online and check it. No matter what I-94 you submitted, they will go and check if your I-94 is valid or not. If ever by any chance they are not satisfied with the I-94, they won't outrightly reject it. They will send an RFE asking if you have a valid visa status because your I-94 expired. They won't outrightly reject it. They will issue an RFE. So you seems to be safe to me.
So Resham asks, if you're on CapGap and are not picked in the H-1B visa lottery, or it's denied, when does the grace period begin? So, okay, so one thing to clarify is actually if your H-1B application was filed in April but not selected, technically the CapGap does not apply to you. The CapGap applies in a situation where your OPT work authorization expires at some point between April 1st and September 30th, and your H-1B application does get selected, in that situation, your OPT work authorization is considered automatically extended to September 30th. So that's what's known as the cap gap. If your application was not selected, the cap gap doesn't apply to you, meaning you don't get that automatic extension to September 30th. Your OPT is still valid until the end date on the EAD, but the 60-day grace period starts from that EAD end date, unless you are eligible to apply for a STEM extension or something similar, or if you've filed something else to switch your status or to re-enroll in school. But the 60-day grace period would start from the EAD end date.
Amar has this question. I'm a physical therapist. I'm an H-1B for 3 years. Can I have a parallel H-1B with a different sponsor and continue working for two different employers? Has there been any change in this administration? No change, no change. In fact, my wife is a physical therapist. She works for 10 different companies at the same time. Obviously, she is a US citizen, but I'm just telling. No, you can file for a parallel H-1B. Nothing has been changed. And I know that a lot of physical therapists and occupational therapists, they do work more than one job, and they can file a parallel H-1B. Absolutely not a problem.
Yeah, so that situation is called concurrent H-1B employment. So the second or third petitioner would just file an I-129 petition requesting concurrent employment.
Jeevan has this question follow-up on what can you do on H-1B? Can he start his own company in USA?
No, usually not. Mm-hmm.
You cannot start your own company. You can buy stocks in company, like for example, you want to buy Apple, Microsoft, or my favorite Tesla, you can buy the stocks in any of those companies, but you cannot open your own company on H-1B. That will be a violation of your H-1B, sir.
Vijay asks if his I-94 is expired and he's waiting for the extension to be approved. If it gets denied, does he need to leave immediately, or is there like a 1 to 2 week grace period to settle things before leaving? It really depends a lot. In that situation, you should definitely be in close contact with your immigration attorney. First of all, you should be aware of your I-94 being expired and the extension being pending. Typically, we recommend upgrading the application to premium processing in that situation to minimize the amount of time that you would be out of status if the I-94 has expired. But we know that there are some situations where that's not possible or not preferable. Technically, there isn't a grace period. If your I-94 is expired and extension is denied, you're considered you're considered out of status dating back to the I-94 expiration date. But from the date of the denial, you're considered to be accruing unlawful presence.
But Rebecca, I mean, if the denial comes in today, how can I leave today? There's no flight today. The typical unlawful presence is that what the rules are that if you're unlawfully present for less than 180 days, you are still eligible to apply for the non-immigrant visa when you go outside the country. So sometimes people leave in 2 to 3 weeks, and they can go back and they can apply for the visa again. I have not seen the consulate penalizing if they would stay for 2 to 3 weeks. And sometimes I've seen people who are in a very late stage of pregnancy. I don't tell them to stay in the country. What I advise them is that if I were you, I would not leave the country immediately based on the physical condition that you are at. And I would tell them that if you're unlawfully present for less than 180 days, normally the consulates don't penalize. They will look into the circumstances under which why after the denial you stayed. Now, if you stayed for 2-3 weeks, that they understand it. But if you stay for, like, if it's 179th day and you leave on the 179th day, they may not take that as very good step that you have taken. Now, unless there are extreme circumstances, if the lady is pregnant, the baby is born, and the baby is not mature enough to take in the flight, that they understand it. But if you're just sitting here idling and trying to do whatever you want to, that is not advisable. I cannot tell people to stay undocumented here, but what I would say is that if I would get a denial and I-94 expire, I may leave in 2 to 3 weeks, but I'm not telling you what to do, but that is what I will do.
Sudhakar asks, so he and his wife are on an F1 and F2 visa and are traveling to India for vacation. She is working as a software developer full-time, I assume on OPT, and they have a valid visa. Is it okay to travel?
You may want to consult your DSO, get an I-20 endorsed for travel. If you're on CPT, I would advise you check with a lawyer. But if you're an OPT working properly, check with your DSO, get an I-20 endorsed for the travel, and then you should be fine.
The only other thing I would add is if you are on OPT, just make sure that anytime you spend outside the country technically counts as unemployment time, and there's a limit on the amount of time that you can spend unemployed while on OPT. In the first initial year of OPT, I believe the limit is 90 days. If you're on the STEM extension, cumulatively it's 120 days. And so if you're outside the country and there's been time unemployed that go beyond those limits, that could affect later, for example, your ability to change to H-1B status. I have a case that has an RFE right now that is asking that very question, asking for the exact dates of unemployment and time outside the country while she was on OPT in order to determine if she went over the unemployment limit. So just make sure if you're going on vacation, make sure it doesn't put you over the unemployment limit.
Ms. Reddy from YouTube has this question. Her parents were being given only 3 months of period of stay in the United States. Can she apply for the B2 extension? What's the process involved? We recommend that you do not apply for B2 extension. I understand maybe your culture, because I may come from, I'm from your culture, but here in USA, the officers don't understand why the mother-in-law and daughter-in-law can stay together for more than 3 months, and they don't understand that. Why the mother-in-law and the son-in-law can stay together in one roof for more than 3 months. For them to understand, it's very tough. And also the purpose for which the visiting visa is given is for you to come and stay temporarily and visit the kids, not to stay here for a long period of time. There's also another point why we suggest that not to file the extension. If the extension gets denied, what happens is that the passport visa will become invalid. And that's the reason why you should not. If they have a 10-year multiple entry visa, you applied for extension got denied, the visa is canceled. That means they have to go to the consulate again and apply for the visa, which most probably they're not going to get it. So you may want to be very careful. Third reason is that there might be a reason why your parents might have been given 3 months. If they're coming here very frequently and staying for a long period of time, they may be, the CBP might consider that they're visiting India and staying here. That's the reason they might have been given 3 months. So in general, the recommendation is do not file, let them go. Otherwise, you'll be risking their visa forever.
Madhu received an RFE for availability of work at the end client, and it looks like while the H-1B application was pending, the vendor changed. What are the chances of success and best ways to respond to the RFE?
Vendor change might not have that much detrimental effect in getting the H-1B approval. That could be clearly explained. Since it's not the change of the end client, it can be clearly exchanged. The job is the same, everything is the same, the vendor has changed, but you do more documentation of H-1B RFE response, Rebecca.
Yeah, I would, if I have that RFE in that situation, I would definitely make the argument that the work at the end client site is the same, that the work is still available and has been there since the filing of the H-1B petition. The main risk I would see is that we could see how an officer would argue that due to the change in vendor, usually the contract between the petitioner is directly with the vendor, not directly with the end client. And so if there's this new vendor SOW that is dated and signed after the H-1B filing date, I could see how an officer, a more ungenerous officer, would interpret that as the specialty occupation work not being available at the time the I-129 petition was filed, and issuing a denial in that case. I would say it's kind of a gray area. It'll depend on the officer. Worst case scenario, if it does get denied, just be prepared to refile really quickly with the same, with the new vendor documents and the same end client documents.
I'm going to go through the questions very quickly from the YouTube. SVD has this question. Can you please advise me of the remote positions? How do you document that?
Yeah, working remotely from home, that hasn't been too difficult to document so far. We identify the beneficiary's residence as the address on the LCA and on the I-129 petition. We need the same project documents if the beneficiary is working on an end client site, on an end client project from home. We still need the contract SOW, vendor letter, and client letter. The only difference is that we would recommend in the vendor and client letters mentioning that the beneficiary has authorization to work remotely from home through the arrangement between the vendor or end client and his employer, the petitioner.
So you're going to put the end client address and the apartment address of the individual on the LCA.
It depends. I would usually ask how much time the beneficiary really is expected to spend at each location. If it's going to be about half and half, we can list both locations, definitely. But in some cases, all the work is expected to be done remotely from the beneficiary's home. And so we have listed the sole work location as the beneficiary's residence before, and it's been approved as long as all the project documents are there and support that.
Chen has this question from YouTube that his H-1B is approved without the I-94. They have applied for change of status. He couldn't figure out why. Is it a USCIS error, or could there be anything else? One doubt that I have is that, is there a chance if you are in a CPT, day one CPT, that may be one thing that might trigger to do the consular processing. The other thing that might want is that to check the application very carefully to see if any of the things were been missing. The third thing is look into in the RFE, did they ask the maintenance of status? If they did ask the maintenance of status, most probably they are not satisfied with the explanation that you have given. So these are a couple of things that I will be careful, look into before I conclude if there was an error or maybe they did it intentionally.
Raju applied for an H-1B extension with an I-140 approval and asked what would be the new I-94 validity dates. Does it depend on the I-140 or the client letter? Yeah, so it is still going to depend on the project documents, like the end client letter in that case. The I-140 approval makes you eligible for a 3-year extension beyond the 6th year of the H-1B, but it doesn't automatically guarantee a 3-year extension. If you're working at a third-party client site, the officer is likely still going to go by the concrete dates that they see in the project documents.
Jeevan has this question. His H-1B got picked up, his term extension is about to expire. Can he continue working or should he has to wait until the H-1B approval? If your H-1B has been picked up, I'm assuming that you did file a change of status application. If you did file a change of status application, you are entitled to work until September 30th on a cap until your H-1B is adjudicated. So at this point of time, if the change of status has been filed, you can continue working until either the H-1B is approved. If it's approved, you can continue working. If it's not approved, you should stop working. Or September 30th is another stop date. In other words, if the H-1B is neither approved nor denied, you should stop working on September 30th.
Harsh is asking, can someone travel while an H-1B amendment is in process? The visa and the I-797 are valid for the next 2 years. So there are situations where having a pending application is a definite no to travel while it's pending, such as a change of status application. If you leave the country while that's pending, it's going to be considered abandoned. For an amendment, it's especially if the visa stamp is still valid and you don't need to apply for a visa at the consulate, travel while an amendment is pending is not as detrimental. The reason we still, you will still be allowed back into the country using that same visa stamp and the I-797 since you're working for the same employer. The actual travel will probably go smoothly. The main downside is the I-94 mismatch potential when you re-enter the U.S., you'll receive a new I-94 issued by Border Patrol, and then depending on when the amendment is approved, there will be an I-94 issued according to the I-94 number that was attached to that amendment petition. And there could be a mismatch, which could lead to problems renewing your driver's license, even your social security number being mismatched. So in general, we just recommend not traveling while an application is pending. Just upgrade it to premium if you can and get it approved before you return.
Gurnath has this question. The H-4 EAD extension is still pending. EAD has expired. Do I need to resign for the job? Can I go for unpaid leave and not get paid and not work at this period of time? Whether it's an unpaid leave or whether you are leaving the job is something that is an internal matter of your company. As far as the immigration is concerned, you cannot work and you cannot get paid in that period. Whether you have to resign or whether you have to leave, be on a leave, unpaid leave, is your company policy. We are fine with either way, but you cannot work and you cannot get paid.
So Zuhaib has a question.
I can't hear you, Rebecca.
Okay, so Zuhaib has a question about his wife's name. It looks like her name appears in different ways in her visa, the passport, the EAD, her driver's license. And it looks like part of it is because probably one of the lines in her passport is blank for her name because FNU is listed in the H-4 visa. So FNU is listed by the consulates in the visa usually if one of the blanks in the passport biographic page, such as the given name, if that's left blank and the entire name appears on the surname line, the consulate will usually print FNU, which means first name unknown or family name unknown. So that's what that stands for if you see that. And yeah, it can lead to a lot of inconsistency in the documents. We usually, when we're filing visa applications, the I-129 forms, any forms with immigration, we go by the name exactly as it appears on the biographic page of the passport. So in order to make everything consistent, I would recommend updating the passport, getting the name corrected there, and then you should be able to get everything else corrected from there.
Praveen has this question, can I go to Mexico or Canada on EAD and AP, which is valid? Will I be able to return with the existing advance parole and EAD without having a visa when I travel to Mexico and Canada? If you have an advance parole, I'm assuming in adjustment of status, you don't need any visa stamping whether you go to Mexico or whether you go to India. You should be able to come back without any problem. Zohaib Zakaria from YouTube has this question. He and his wife got a visa approved. We are going for stamping. Do you think so? There can be some issues at the consulate. You're the queen for the consulate.
There's always a risk at the consulate.
I mean, why? It's a perfect case. H-1B is approved by USCIS. Can it be still denied at the consulate?
Yes, definitely. Unfortunately, it should be the role of the consulate to just confirm that the terms of employment and the situation that's described in the approved I-129 petition still apply. They're meant to just confirm during the visa interview that the H-1B petition is valid, that you are the beneficiary that's described in the petition. They are not supposed to re-adjudicate the petition or reprocess it right there on the spot, but unfortunately that does seem to be what some consular officers do, especially in the past 2 years, and especially with the issuance of the Buy American, Hire American executive order. It's given consular officials a lot more ground to deny or question or put cases in 221G for any reason that they feel is valid for the protection of American workers. It's a very subjective standard. So it's always a risk to go to the consulate to apply. Definitely there has been an increase in denials at the consulate, an increase in 221Gs. So if you do go, I would definitely leave your return trip to the U.S. somewhat open-ended. At the very least, expect a 221G and plan for a 221G, which can take about 3 weeks. We've talked to a lot of people who have received a 221G and have had to reschedule their return flights because they need to stay and wait in their home country while the 221G is being processed. There's no way to premium process a 221G. There's no way to expedite it. Following up at the consulate seems to just aggravate them. So really the only recourse is to wait in that situation. So if you do go, just be prepared to wait possibly 3-4 weeks beyond the visa interview date.
Rajni has this question. Did anybody got H-4 plus EAD approved after you filed the litigation? Yes. We got the H-4 and the EADs approved for a couple of people that we filed under the litigation. And some people ask the question, I don't know why they ask the question, was any of the Nebraska Service Center H-4 EAD that was filed after March 11th got approved? Yes, Nebraska Service Center that we filed after March 11th H-4 EAD was approved after we filed the litigation. That is being going on very smooth. Seems that litigation is the only way to get the approval right now. One of the questions that came out, age out situation for the kids, especially if they're becoming 21. Is there an easy solution that you have, Rebecca, for them?
Not an easy one, unfortunately. So I assume it's H-4 kids who are reaching the age of 21, which is when they are no longer considered children for immigration purposes. So in that situation, they need to switch to another visa status. Usually F1 is the preferred visa status because by that age they're usually in university here in the US. And unfortunately the main option to get into F1 status is to file an I-539 change of status application. It's not really an option to go to the consulate at that point. So if you are in that situation, our main recommendation is to plan ahead and to file the I-539 change of status from H-4 to F1 as early as possible, because I-539 processing times, as we've mentioned on here before, are taking extremely long, 1 to 2 years, sometimes more, depending on the service center. And if the I-539 application to change to F1 status is still pending at the time the child turns 21, you're going to need to file bridge petitions, bridge applications to request this visitor visa status, even though they have no intention of being here really in visitor status. That's what's necessary to bridge the gap between the end of their age out until the F1 application can be approved. Definitely consult with an attorney because you have to get the timing right. You need to file possibly 1 or 2 additional I-539 applications and make sure they're filed on time in order to get the F1 eventually at the end of like 18 months or so. I
would recommend that when the student is 19 years old, that's when we recommend that you apply for a change of status from H-4 to F1. That's the ideal way. Instead of doing the B2 extensions, you can avoid that, because once the child turns 21 and the F1 is not approved, as Rebecca has pointed out, you need to have those bridge applications. It's too expensive, too many things to go through. I would try to avoid it by trying to take the action when the students are at 19 years old. Can we be able to file for the kids who have crossed 21 on the 485 application? That question came in from YouTube. The answer to the question is that mostly no. There is some period of time that we can deduct from their age based on how many days the I-140 is pending. There are some other creative ways that we can come up where we can file one more I-140 for the same applicant and make that pending for a long period of time, especially if the kid is about to become 22. I would recommend you contact Emily Neumann in our office. She's very good in those things. Only if they are going to be off by about 6 months to 1 year, some things, we might be able to save those kids and apply the adjustment of status. Once we apply the adjustment of status, they most probably are safe. They should be fine. It's until we file the adjustment of status, if they become 21, that's when the entire danger zone comes in. As I said, some time of their age may be deducted based on the I-140 pending. There are some creative ways of filing one more time I-140s we can discuss personally, but in general, I mean, you don't have much leeway. They may be kicked out of your 485 and they have to become independent on their own. And they have to swim through the whole ocean, the same thing what you swam. That's the bad part of it. And the waiting period for them, if they file the green card, might be forever. So, that's a sad situation. We highly recommend that you contact the senator on the Senate bill that is pending right now to take the hold off. Contact the Senator Rand Paul. That's the best way to get it. If they take the per country quota limit off, I for sure know that we can resolve these issues, not going through all these things, just file the adjustment of status. So you may want to get the Senate bill passed to get your problems resolved. Anything else, Rebecca, before we close?
So I had a few questions in Facebook about EADs expiring for H-4 visa holders and if we recommend filing the lawsuit. As we discussed, it does seem to be the only way now, the only effective way. And so if you'd like more information, we have a website, rnimmigrationlitigation.com, where you can find more information specifically on the federal litigation that our office has been filing, and you can get more information there on the procedure, the process, and to set up a consultation with an attorney to discuss to see if it's a good option for you.
Anything else, Rebecca?
No, I don't think so.
Sorry, we cannot get to all the questions. If you want to make an appointment with Rebecca or any of our colleagues, you can check at RN Law Group. Our schedules are available online. You can book an appointment. Don't forget that we do have a free conference call every single day. You can check the details of those things at rnlawgroup.com. You can please subscribe to rnlawgroup.com news section, and also our partner Emily Neumann has a blog called Immigration Girl. She updates it very fast, and as soon as any business immigration news comes in, she updates it. Thank you, Rebecca, for coming. Thank you, everybody, for joining in. Thank you.
Thanks.